Good evening, everyone. Welcome once again to Legal Hour with Legal Time with Connaughts. As you know, in this program, we discuss recent updates in the immigration law. We discuss different categories in under the immigration rules, any recent updates when it comes to the case law, and we try to provide you the best advice we possibly can. Once again, we have Shahryar Khan with us today.
Thank you. Good evening.
Today we have decided to start with different options we have when it comes to spouse visa applications. So if you have any questions related to spouse visa, please log into your Facebook accounts and you can send us live questions. You can also send us text messages, you can send us emails. But for now, if you have any pressing question, you can come live and ask us these live questions. We'll be happy to answer. So Shahryar, starting with the spouse, different options we have for spouse visa. One of the common options people know is the threshold of 18,600 for entry clearance and for extension as well.
Correct.
As indefinite leave to remain.
Yes.
Are there any other options available for these applicants if they don't meet income threshold?
Yes, well, starting from the top, as always said, it's spouse visas that we are focusing on today. And the minimum income threshold requirement is £18,600. So that's like an annual income that the family or the household must be in receipt of in order to qualify for a British national, for someone with ILR to call over his wife. Of course, that requirement increases if there are children who are dependent and outside the country and not British. So then that's increased to, from 18,600 to 22,400, 24,600 and so on and so forth. So the way to meet this requirement, the simplest case, of course, as Uwais would agree, is that when a client comes to us and he says, I'm employed in a third-party company. In such a case, of course, then the sponsor needs to show that he's got 6 payslips, 6 corresponding bank statements, and a letter from the employer to show that he is working as stated on the terms and conditions. So those are the kind of cases which, of course, any immigration lawyer enjoys doing the most because it's the most simplest. But of course, as in all things in life, when it gets complicated, when the client says, actually, I've got 2 sources of income and or I have my own limited company, I'm self-employed, Uber drivers are a classic example, and or if I'm working in a family member's company.
Or change employment in the past.
And of course, there's been a change in employment. So then there are different factors. Of course, the Home Office has tried to cater to all possible situations, but in some cases we've realized that that's not the case, and then we need to make an application going outside Appendix FM or the rules that the Home Office has stipulated. But coming back to it one by one, so one thing to bear in mind is that it's not a question of giving 6 pay slips and bank statements if you are self-employed or working as a director in your own company, or the third, which is something which a lot of practitioners miss, that if you're working for a company that is owned by a family member by majority. So by family member, it's immediate family members, brothers, fathers, sisters. If any of them own a company that you work in, so although you will have all the requisite paperwork, the 6 pay slips and 6 bank statements, it won't be enough, and the Home Office to require additional documents which they've set out in section 9 in their list of required documents. So what happens is, as a thumb rule, then what you need to bear in mind is that it's not the last 6 months that the Home Office will look at, but actually the last 12 months. Just because, of course, there's concern that it might be abused because you're a director of your own company or you're working for a family member, so they want to see more evidence that this income has actually been derived by you genuinely. So what they then, as a general rule, need is 12 months company bank statements to show that the company was earning this income. They also...
Sorry, just to...
yes.
This 12-month period, is it from company tax period or...
Yes, so typically, if it's a limited company, then it would be for the companies, it would be the last financial year for that company. So it's a good question to ask because people are confused about that. So it's the last financial year that that company would have filed the tax returns for. So then you would require the 12 months bank statements, 12 months personal bank statements to show that the funds were coming out from the company account into your personal account. You would also need to show that you filed the tax returns, and that's an important thing that the Home Office is keeping an eye or a check on applicants to see that they've actually paid tax on this income. So if you're drawing income from your own company, there is potential abuse. But of course, if you filed a tax return, you've got a corresponding CT 600 and an acknowledgement by the HMRC that the company was in profit of, let's say, £20,000, this person has taken £18,600 as the director of the company, then they're happy. So basically then you need 12 months bank statements for the company and yourself. You need corresponding tax evidence, and you need to show that of course the company is genuinely trading. What they also would require, of course, as always asked, if it's the last financial year, which has been quite some time back, they would require recent pay slips to show continuing employment. The same is a similar case for self-employed applicants, but as opposed to providing their CT600, they would be providing a SA302 as opposed to providing their company's bank accounts. They would be providing their self-assessment again for the last financial year to show that they've earned the actual amount. So that those are some of the additional documents, but in comparison I think it works out to about 8-9 additional documents you would need to file if you are not working for a third party company but working for yourself or a family member. So I guess that covers at least those who are employed.
Yeah.
Yes.
If someone has, let's say, any income from rental income, for example, or they are not employed by a company but they're taking dividends out of the company,
Yes.
common misconception is they will have to file their personal tax returns to show that income.
Yes.
Well, now we know from the rules this is not the case.
Yeah, the rules strictly, if you read it, although one wonders why in this particular rule, especially for rental income, they specifically only really ask for evidence that you're receiving the rental income. They ask for the evidence of what is the management fee or whatever is being done, so your agreement with your agents and the tenancy agreement, ownership of the property, and that's that. So yes, there is a misconception that you would need to provide corresponding tax evidence. In some cases, of course, if we really want to be strict about it or black and white about it, rental income is taxable income and it should be disclosed on your self-assessments. But of course, that's another question.
Excellent. Anyone who does not have any employment or additional income but only has savings, what exactly? So
the way is, again, yes, an interesting question. It is possible actually to rely on being self-sufficient, on being on having savings. The amount is about £62,500, which you will need to show that you've maintained for 6 months. Again, applicants have in the past, I've seen, believed that they just need to show that they've got the savings or they just received the funds or a third-party letter. No. The funds must be maintained untouched for at least 6 months. So that's for the spouse, 62,500. Again, if there's a dependent child, that amount increases. It is also possible, I've seen classic cases where sometimes the sponsor would be only earning £14,000 or £15,000, so they're short by £2,000 or £3,000. So it is possible to supplement savings with salaried income. And the formula, of course, is that whatever is the shortage, that needs to be multiplied by 2.5, and then you need to add £16,500 to that particular amount. So you would think that if you're short by £3,000, you need to show £6,000 in savings. No, the savings will always usually amount to about £20,000 because 16,500 is a base amount which gets added on to the shortage amount. So
for example, someone's, let's say, short £500,
yes.
So they will have to multiply £500 into 2.5 plus £16,000. That would be the additional income, the savings.
The additional savings that they will have.
And these savings needs to be in their bank account for 6 months.
For 6 months, yes.
Yes. Okay.
So two.
That's very.
We're kind of relying on two separate rules to meet the requirements, and it's not always possible to mix and match all possible sources of income with, of course, savings. So you just have to see which one can you mix with the other one, because the Home Office isn't, I think in one case which they face difficulty is that if you try to combine salaried income with non-salaried income, then it gets difficult. So they don't allow it in some cases.
I mean, within salaried income, if, for example, someone works on hourly rate or income fluctuates,
yes.
Is there anything different in terms of providing evidence?
Yes, my understanding on that is that you could actually then also rely on the actual received income in the last 12 months. So you could actually, you don't necessarily need to rely on the contracted hours, but if you're working on a 0-hour contract or if you're working different as you suggested, then it's possible to rely on the funds that you've actually received.
But for the past 12 months rather than 6 months, which
yes.
is in general employment. Okay,
yes.
That's very useful. We've got a lot of questions online, so shall we take these questions before we go back to our... one of the questions is regarding bringing parents to the UK permanently. My understanding of this question is that someone, we can discuss both, someone who is settled in the UK and someone
Yes.
who is not settled in the UK. What are the options they have when it comes to calling their old parents for
Sure.
permanent residency?
Right. Well, there is a route for dependent parents, for British nationals or people who have ILR who are settled in the country. You can sponsor your parents to come to the UK. It's called the adult dependent relative route. It's actually been challenged in the courts as well for being too harsh, too tough. The challenge didn't work out, so the rules stand. And what you need to show as a starting point is that, of course, the old rule, I would say before 2012, used to have a factor that the parent must usually be over 65-year-old. So at the back of our minds and the judges, I would still believe that it is a factor. Age does play a certain role to show that you've got parents who are elderly and dependent on you. So elderly is one factor. Of course, you don't need to prove that past the identification documents, but the dependent factor, the Home Office really wants exceptional factors to show that it's not a case where you can just send them money, because that's what they suggest, that why don't you buy help? It's much cheaper to obviously get even medical help and or otherwise in Pakistan or India or third world countries. Why did you need to call them over physically? So you will need to show that any help that you can buy from money would not be enough, and you need to care for them beyond the financial savings or the financial dependency that they have on you. So in practice, how that would work is that if you have a dependent parent who's living abroad, then you would need to show that you've been sending them funds regularly. You would need to show that it's no longer sufficient to simply send them money, because that money is not going to be enough. You need to give them further care, which could be physical and mental care. So if a practitioner is, of course, also backing the fact that they actually need to be in your physical presence, it would help. So you would need that evidence combined with the financial evidence. And then, of course, you need to show that there are exceptional reasons to the cases, exceptional circumstances, as the Home Office puts it. So that, again, is just a combination of all the factors. It could be health, it could be a change in circumstances. If one parent has passed away, that could be a trigger factor, that's why you want to call your second parent down. If there's been any other change, if your parents were living, or if your parent was living with a younger or any other sibling who's now moving across somewhere else. So I've seen the most successful cases are where you're able to show to the Home Office there's something has happened recently, as a consequence of which the dependency has either increased or just been created, and that's why you need to call them down to the UK, because otherwise the question really is that why can they not continue living as they are? What's changed? That's the question that they ask you, that's not in the books, and that's what you need an answer to. So yes, there is a route. It's a complex route. You will most certainly need lawyers. You'll need to consult with them before you attempt such an application, and that's what you should do. I do have cases where people come down and say our parents have a 5-year multiple visa or a 10-year multiple visa, but we'd rather they get a dependent visa. What I tell them is that unless they're going to actually move here and live here with you, do not really mess with the visit visa, because once you make an application for a settlement, you do put in question any future visit visa application or any future entry as a visitor, because the Home Office will say you've now shown us an intention to settle, and that's why we don't really think you'll come as a genuine visitor. So something to bear in mind. Again, you need to think this through, why you're making this application, and will your parents be prepared to take that risk that they will not possibly be able to come on a visit visa in the future.
And category Shiraz discusses for the entry clearance visas, Shiraz, is that correct?
Yes, that's entry clearance. So that's usually if your parents are abroad. Of course, in some cases, again, that's a good question. We've seen that if parents were to travel to the UK, or if a parent were to travel to the UK, and well, during the visit their circumstances change, it would be medical reasons, which is usually the cause, and the dependency increases, then you're able to make a human rights application in country. Now, of course, the best way to do that is that to show the Home Office an analogy with their adult dependent relative rules, to show that you have this category. We have our parents in the country, or our parent in the country, but they're not in a position to go back because of the reasons A, B, C, and that's why we believe that you should allow them to stay inside the country, outside the rules. Those cases are, of course, again decided on the genuineness or the merits of whether the Home Office believes the change in circumstances. But it is again then possible to make an application in country as well. Interestingly, of course, both cases carry rights of appeal under the Human Rights Act. So whether it's refused from abroad or from in country, typically there should be a right of appeal, and gives you an opportunity to raise this matter before an immigration judge if refused.
Yes, and with experience, I think one thing we've realized that if we make these type of applications in country, even though in-country applications are outside of the immigration rules generally, as compared to entry clearance applications which are within the immigration rules.
The more
I had more success making applications in country, even though I don't, like you said, we don't advise clients that, to jeopardize their visit visas or mess up with their visit visas. But if they are in a situation that something happened after their parents entered the UK and they can't go back now, an application was made in country outside of the rules. I have had more success making these applications than entry clearance applications in these type of matters.
I think it's
don't
more
know what your experience.
I think it's less than a question of law. It's just probably that comfort that the Home Office has that if you're blocking someone from coming into the country, then their human rights are possibly even less engaged. But if someone's in the country and they're actually enjoying private and family life together as one family unit, it becomes a challenge even for the Home Office to actually enforce removal, especially on these vulnerable citizens. And that's why, again, as a consequence of somehow finding themselves in a situation of checkmate, they grant leave inside the country.
Sure. And next question we have is regarding the nationality matter. Someone's asking if a father has ILR and child is born outside of the UK, would child be qualified for base citizenship? Well, simple answer is no, because a father is not a base citizen, so nationality cannot be passed on.
I guess you don't have anything to pass on.
Exactly.
Only if you are a British national and you have a child born abroad for one generation only, the first generation would be British. If they then go on to have further children, then it stops. So
depending on whether nationality is by descent or otherwise other than by descent, so you can pass it on if it's not by descent, unless obviously double descent applies, which is a complicated matter.
Yes.
So if you have a nationality issue, make sure that you contact us and provide us information. We'll be happy to discuss it.
Yes. But the answer to your question was unfortunately no.
Yeah.
Just to be clear. Yeah.
Yes. Another question we have is, it says, hello guys, my mother's mother-in-law's case was refused in 2016. Want to make an application for visitor's visa. Is it possible? Well, we were discussing, I think a lot of questions are related to visit visa, so I think it's the right time to discuss, like we were mentioning in the beginning, that there is no right of appeal on this type of visa. So if someone is refused visit visa, what are the options they have to challenge that decision?
Yeah, I mean, two things happen, right? One, what I've seen is, which I discourage, is repeat applications, where applicants believe that, they've refused my application for this one particular reason, so I'm just going to wait 6 months and reapply and things will change. No, the Home Office will always, as a starting point, even in the answer to your question, look at the last refusal. So if this gentleman were to make an application again for his mother-in-law, they will look at the factors as to why the application was refused in 2016, and we need to give reasons, whether it's us lawyers or the mother-in-law giving a statement to explain that what happened then, what were the reasons, what you want to say in response. And then of course, regardless you've addressed those concerns, you need to show them now that you've got sufficient grounds to make a valid visit visa application. The most important thing, of course, in a visit visa application is to show that you've got strong ties, strong economic ties, financial ties, family ties to the country you're applying from. Because the Home Office, the UK being a little island, is scared that you're just going to come and not go back. So you need to show them you've got good and sound reasons that you will go back. That's the most important thing, I think. And then beyond that, of course, you need to show them that you're either employed or self-employed or working, or you've got family. So all those factors are combined. So visit visa applications back in the day would be simple, but now when we're looking at these absolutely high, I think last was about 93% refusal rates overall across the board, it's a good idea to take advice, even if you're confident that you filled out the application form. Speak to a lawyer, because sometimes people put in unnecessary additional information which confuses the Home Office, because at the end of the day they just want to see that there's an applicant. It's like a mortgage application, that there's less risk that that they'll stay in the country, so they want to see strong ties, so a job or being in full-time education. And of course, another problem, especially particularly from South Asia, is when you give bank statements with huge deposits coming in, and that is a trend abroad, which we are all aware of, that a certain amount would be deposited by cash, then withdrawn. That doesn't happen in the UK, and that's not something that the caseworkers understand. So if they see large transactions, especially in the last 6 months, coming into the bank account or coming out, they will ask you what is the source of this money coming in and going out. And it's not enough to say that a friend gave it to you. You need to really explain yourself why or what was the reason such large deposits or transactions are being reflected in your bank account. So that's one thing. Visit visa applications are successful, so take professional help. And number two, if they are refused, and if you think you presented a good case with the help of a lawyer or without, then although the refusal letter will say there's no administrative review, there's no appeal, and people think that's the end of it, it's actually not. So if it is an unfair refusal and you see a good solicitor or a good lawyer, he will tell you that he can challenge it by a process called judicial review. Now, people living here or who have gone through the immigration system might think, oh God, judicial review is a nightmare. But that's different. When you were here, or perhaps asking for your HSMP application to be refused, it could have been tougher. But judicial review for visit visa applications are far more simpler and far more cheaper. We actually take on cases even on a no-win, no-fee basis if we think it's a strong enough case. So by all means, if you got a visit visa refusal, instead of applying again or doing anything else, send it to a lawyer, send it to us, and we'll give you our advice on it.
Excellent. And obviously, if it's a judicial review application is successful, there's a good chance that we can recover their cost as well.
Exactly. I mean, if there is any cost, then we are able to recover that.
Yeah.
So, yes.
A questioner is asking regarding benefits when it comes to spouse visa application. It's not very clear, but my understanding from the question is, can benefits be taken if someone is applying for a spouse visa? A lot of questions we get asked is, for example, from spouses that I am not applying for the one who is under immigration control. I'm applying in my name. They don't realize that any benefits they apply are family benefits.
Yeah.
So whether their sponsor applies or the applicant,
Yeah.
both are effective when it comes to the application.
Correct. It's
Now
the household that the home
exactly.
office
Now, if it's an in-country application, they have a child,
Yes.
they may get away with this and visa is extended, but they will be put on 10 years route rather than the 5-year spouse visa with their own.
Yes.
Entry clearance applications will be very difficult if sponsor is taking benefits. Very difficult.
I mean, the way it works is the Home Office hasn't sort of magically come up with this 80,600 figure. They've of course looked at all the possible recourses to benefits, and they've arrived at this figure because if you're receiving this amount as your income, you'd actually not be entitled to any form of public benefit anyway. So of course then the question would be either you're sort of misleading, under declaring your income to one tax department or the revenue department or the benefits. So basically no, the answer is if you're taking benefits, which is housing benefit, income support benefit, all those kind of things, then your application is not going to be successful. Even if it is successful, your wife will then, or your sponsor, the applicant will be put on a 10-year route to settlement, not a 5-year route settlement. What I didn't cover, of course, is that yes, there will be cases where applicants will simply say, yes, this is all I earn, 15,000, 16,000 pounds, that's the case, I still want my wife in the country. Maybe there's a dependent child, which makes your case more compassionate. In that case, it is possible, and that's something that the courts have considered, that you will then, the Home Office will first look at your case inside all of these calculations, and if you still don't meet the requirements and there are compassionate factors in your case, you will be granted leave outside the rules, which means yes, your spouse gets to come to the country, but that spouse will be on a 10-year route to settlement, which means 2 additional applications. You'll be paying IHS twice on top of that, so it's going to work out to be much more expensive for you.
The nationality question we addressed, gentleman has come back saying that father is now a citizen, but because nationality is obtained after a child was born abroad, obviously nationality cannot be passed on to that child, is my understanding.
Yeah, that doesn't change. Even if you are now British, although your child was born outside the UK when you had ILR, the situation doesn't change. The situation only changes inside the UK. So inside the UK, if you have a child born while you only had ILR, you don't need to be British. That child is British by birth. But this child needs to be registered. He is not what you call British by birth.
So that means income threshold needs to be met if father wants the child to come to the UK.
Correct. Yes.
Provided if child is coming with the mother. If not, then sole responsibility application, which we have actually discussed in one of our previous videos.
Yes.
Okay, so moving on to the next question. We have a question regarding TOEIC. My understanding is someone's gone through TOEIC appeal process and waiting for the decision. So they wanted to know their options because Section 10 apparently, or the TOEIC allegation was raised some time back, and now they have addressed it in 2019. So if they are successful, would their previous time be counted towards their long residence or not?
Yes, I mean, let me rephrase this. So let's say if there was a revocation of your existing leave, a curtailment by a Section 10 decision as always suggested, and then 2 or 3 years as time has progressed, you made a human rights claim, as a consequence of which you've been given a right of appeal, and you go to court and the judge makes a finding in your favor, then that means that that original decision 2 years, 3 years, 4 years ago was unlawful. I've had a case successful recently in which the allegation went back to 2014. That's when my client's visa was actually curtailed, but we had a right of appeal this year and we won on the TOEIC point. And after that, when I wrote to the Home Office, I made it clear that of course you need to now accept that your original decision of 2014 was unlawful. So the Home Office has written back to us and confirmed that yes, that means the client has been legal throughout, and coincidentally he's now been here for more than 10 years, so he qualifies for settlement. So yes, if there has been a TOEIC allegation and you successfully challenge it, it means your leave from that point till today should be either 3C leave or should be lawful leave. But of course, we're assuming some factors here. It's good to get specific advice if you email us your papers or give us a call.
Thank you, Sharia. Now coming back to what we initially planned to discuss.
Yes, I mean one interesting area of law which has popped up and we've realized that not a lot of applicants are aware of, and it's something that you should be careful of, is that you need to drive carefully. And what that means is that if you're not settled in the country and you're looking to make an ILR application in the future, if you get a criminal conviction as a consequence of any traffic offense, by that I mean that, for example, is driving without insurance, then because it's a dishonesty, it's a dishonest offense, it's an offense that requires dishonesty, or at least assumes on to a certain degree, what the Home Office will do is that they will refuse your application on mandatory grounds. So actually you can't really even say this happened or that happened or my friend told me this and I thought I was insured. No, it doesn't matter what was the reason. If there's a criminal conviction as a consequence of a traffic matter, then you will have to wait 2 years. So a classic case is that if you're a tier 1 entrepreneur looking to make an application this year, but you end up having a criminal conviction because of a traffic offense, then you'll need to apply for an extension, keep your business running, keep the jobs running. So I mean, it's a lot of cost depending on what your future plans are. More than anything, it delays you getting your ILR by at least 24 months. So the question really is that if you have any conviction in the last 24 months, then what's going to happen? Home Office is most certainly going to refuse your application. We have seen that there is some element of discretion in where there are fixed penalty notices or there are convictions which are not from the court. Well, they're not really considered as convictions because they're not recorded, and they're more considered as something that the police has sent across to you and you've accepted. Nationality applications are more trickier because then they see if there's a trend of you abusing or a certain form. So even if it's a fixed penalty notice but you've got 3 of them for speeding, so although you've not lost your license because you've only got 9 points, they could still refuse your nationality application if they see repeated offensive behavior, even if it's not a conviction.
And how long is the time frame? My understanding is for nationality it's 3 years, correct? If there is a conviction outside of the court even.
Yes. So I mean, the starting point really has to be that conviction should be spent. For ILR is 24 months. But actually the conviction traffic offense, usually most of them now as per the new laws become spent in 12 months unless they're custodial. So although they spent in a year, the Home Office would want 24 months before you can make a successful application for settlement. For an application for British nationality, they look at everything in the last 10 years. So they're looking at your good character. So of course having any offenses in the last 3 years are definitely detrimental, but even beyond that actually a good example is that if you breach an immigration condition at any point in the last 10 years, which could even be that you didn't report when you were required to, that another good example is that some people back in the day, of course, acquired leave as a consequence of first being illegal. So if the illegality falls in the last 10 years, they would refuse your application.
Excellent. Another question we have from someone, it's a partial question really. Mother has a visa already for the past 1 year and she's asking if she can apply for children's nationality. She hasn't mentioned She's saying 10 years and 3 years old child. She hasn't explained what the current status for the children are, whether they're born in the UK or not.
Yes.
So just to summarize, if child is born in the UK and lived here for 10 years, then you can apply for that child, where you can register that child, so that child can naturalize in the UK. Other than that, unless one of the parents are settled in the UK, you cannot apply for child's nationality. Child will have to apply for leave to remain, even though child is 10 years old, if child is not born in the UK. Same applies for the other child who's 3 years. If child has lived in the UK for 7 years, can apply under different category, which we'll discuss in a minute. Or if mother has a visa, child can apply. I mean, this is my understanding. For
Yes.
3 years, can you elaborate a bit what type of leave this child can apply if mother already has a visa? She hasn't mentioned what type of visa, so we can assume there's some sort of.
I mean, if usually the way it works is that both parents would need to be settled in the country for the child to obtain settlement as well. The only way around that is that if there is a separation and the family is not together, then if even one parent has settlement in the country and that particular parent has custody of that child, then they're able to obtain nationality as a consequence of her or his settlement. I think we'll need more details in your case as to what you mean if your family is together, you and your spouse are living together, and you have a child who's 3 years old, and they would normally qualify with you when you complete 5 years in the country.
Another trend which I'm seeing from the Home Office is, if a lot of times parents, when they used to make their settlement applications and there is a child in the family, they don't tend to make the application for the child with an assumption that once they got the indefinite leave to remain, they can make a naturalization application for the child.
Yes.
The Home Office actually is writing back to them asking why have they not made application for the child, provided child has existing leave or not.
Yes.
So any comments on
I mean, I don't know, it could either be a case of Section 55, the Home Office has a duty to take into consideration the welfare of a child, so maybe they're doing their job properly by asking the question, what happened, where is the child, which is a good thing, and or it's a financial consideration, they are going to be left out of pocket by about £2,400 and they want you to pay the fee for the child to get ILR before you're making a nationality application. But I think it is fair to say that the child is living with you and all is well, and you simply say to them that you've chosen not to make this application because the child would, as a consequence of your indefinite, qualify for British nationality.
Okay, that lady with nationality was 10 years,
Yes.
who had a child 10 years old, came back. She's saying that both children are born in the UK, so the one who's 10 years old can naturalize now.
Yes.
straight away.
Yeah, the one who's been born here, has been living here continuously for the last 10 years, qualifies by virtue of Form T, right? It is that you make an application.
I understand mother's applying for her citizenship as well, or permanent residency. If she does that, then child who's born in the UK and 3 years old can also naturalize.
Yes, then the child could nationalize as well if the mother is applying for nationality. Yes.
Another question we have is, got a lot of questions. For 7 years policy, someone saying that they have a child who's 7 years old, so what type of documentation required? It's a very loaded question. But
Yeah, so on a basic level, that you need to show that the child's been born here and the child's been living in the country, and of course that meets the first two requirements. The Home Office also wants to see that there are reasons as to why the child will not be able to settle back into the country, so it's a good idea in a combination with all the school reports and the achievement certificates that you have either a private social worker or a private psychiatrist to say, or well not to say, to basically have an assessment as to what would be the impact on the child and whether it would be in the best interest of the child to be sent back or to be given leave. Of course, I think it goes without question, most experts on this point do believe that if a child has been born here, living here for 7 years, then it is in their best interest to stay in the society which they only are aware of. So it's a simple rule, but it's a complex application. A lot of cases still do get refused. We're having great results on the same day service. We're making application on the same day and they're all being approved this year, most of them, which means we're being very thorough with the preparation of the applications. Good idea. Speak to us and we'll guide you on this.
And if child is not born in the UK but lived here for 7 years and is under the age of 18,
still okay, still same thing. Yes, the rule would still apply if the child is under 18, has spent 7 years. Still, the 276 AD applies.
Another related category which is hardly discussed on immigration forums is if a child is 18 or over but under the age of 25.
Yes.
When under 276 AD, there is a category that child won't be a child anymore, but that person can apply
the half-life test.
Half-life test.
Yes. So of course, what Oais is referring to is that even if you are over 18, there is a rule within the immigration rules which says that if you've spent more than half your life in the country, then there is a presumption that you've built a strong private and family life in the country, and under that rule, you're able to make an application for settlement in the for application initially to be granted leave, and in due course for settlement. It's called the half-life rule. So another example is that even if you're over 18, but the 20-year rule, which is basically that if you spend 20 years in the country unlawfully, then too you're able to make an application.
Sure, excellent. I think that's all the time we had for today. Is there anything else you want to add? Or?
No, I think we did go off the topic because of course we started getting questions, which is good. Of course, we want to interact more with the clients. But again, case-to-case thing, we try to give brief advice here. We do not charge for initial advice. So if you've got questions, send us an email, give us a call, then we can give you really bespoke, proper advice. Really, we want to make sure we get it right before we really charge you or take up a case.
Excellent. And don't forget to go onto our Facebook page and like it. By doing so, you will get regular immigration updates. You can also go onto our website for regular updates. We write on different topics regularly, so you will update yourself on many issues. So make sure that you follow us on Facebook, and when we are here next time, we have your questions prepared, because we're happy to answer any questions you have. Thank you very much for your questions today, and that's it. Thank you very much. Have a good day.
Thank you for tuning in.